Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California. My firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about a specific law that came into effect in January of 2022. What we're talking about is Penal Code Section 1170 and Penal Code Section 1170.1, which is part of SB 567. And what that said is, when you're dealing with California sentencing, the judge can only sentence someone to an upper term. I'll explain what that means in a second. Can only sentence you to an upper term if you agree to it, if you stipulate to it, or if it's proven beyond a reasonable doubt that there's more aggravating than mitigating factors, whether before a judge or before a jury at trial. Okay, so let's break that down a little bit, right? We're talking about aggravating factors, we're talking about mitigating factors, we're talking about upper term. So let's understand California felony sentencing. All right, easier said than done. On felony, exclusively, with exceptions for in California, usually dealing with a lower term, a middle term, and an upper term. Maybe the lower term is 16 months in prison, the middle term is 2 years, the upper term is 3 years. So what 1170.1 now says, effective in January of 2022, is in order for the court to sentence you to 3 years instead of 2 years or 16 months, you either need to agree to it, and there's reasons why you might, depending on how many other counts may be getting dismissed or what may not be, or the case goes to trial. It's really important. It shaves off the sentence if you're convicted of a crime, whether convicted at trial by a jury, convicted by a judge, or whether you voluntarily plead guilty, unless you stipulate or agree that the upper term should be a part of your sentence. Be really interesting to see how California courts, specifically here in San Diego, apply AB 1170.1, Penal Code Section 1170.1, and how that affects offers from the district attorney, how that affects sentencing, how that affects, what type of custody credit you wind up getting when you go to state prison, if you go to state prison, or if you're in county jail serving a prison sentence, right? Quote unquote local prison. Really interesting. We're on top of it here at the firm. Obviously, we'll be continuing to report back on it as we see cases that we have be affected by, PC 1170 and 1170.1, specifically the modifications relating to upper term sentencing, being the exception, not necessarily the rule, or even pretty normal anymore. All part of California's sentencing reform, where you're going to see people serving less and less time for offenses. Be interesting to see what the DA does to counter that. Interesting to see what judges who may not agree with it do to counter it. It'll be interesting to see what the defense bar, at least those who are up on these things, do to maximize those benefits for their clients. So if you have any questions about felony sentencing in California, particularly in San Diego, you can always reach out, give my firm a call, 619-295-3555, 619-295-3555. Again, my name is David Shapiro, San Diego criminal lawyer.